Welcome to the 2026 Gladiator Online World Championship round. We started the competition with 50 competitors and we are down to our top two. These students were not only outstanding in the preliminary rounds, they just defeated outstanding opponents in the semifinals. And we figured that with competitors this good, we needed a final round panel to match. And so I'm thrilled that this group has given up their time and expertise on a Sunday to boot. And I'll ask each of you to introduce yourselves. I'll go clockwise around my screen. Uh, Rory,
Hi everyone, I'm Rory. I'm currently about to start 2L at the University of Toronto, and I was the 2025 Trial by Combat champion.
that is our one-on-one college mock trial national championship. Isa,
Hi guys, I'm Isa. I'm about to go into my senior year at the University of Georgia, and I was the 2023 Gladiator champion.
Amberlyn,
Hi everyone, I just graduated from the University of Chicago and I was the 2026 TBC winner.
Simone,
Hi, everyone. My name is Simone. I'm a civil defense litigator and currently starting my first year full-time faculty as a visiting assistant professor in trial advocacy at McGeorge School of Law in Sacramento, California. And I was the 2020 Top Gun champion.
so a one-on-one online national champion at the law school level. Joe Lester, oh, looks like we lost Joe for a second. We'll give him a second to get his tech fixed, but I'm going to introduce him. I'll brag about Professor Lester. Uh, he is a professor at Nova Southeastern Law School in Florida, and he is a two-time winner as a coach of Top Gun, the one-on-one law school national championship. Ken,
Yeah, my name's Ken Johnson. I'm almost a 40-year lawyer based out of Houston, Texas. I do complex commercial litigation around the country. I was a national champion advocate in law school. I trained a couple of national championship teams, and for the last 5 or 6 years, I've been one of the folks that leads the AAJ National Mock Trial Competition.
and that's how I got to know Ken. And finally, I don't want to pick favorites, but she's my student, Ria.
Hi everyone, my name is Ria. I'm an incoming 3L at UCLA Law and I'm on the trial team.
Ria also is a undergraduate national champion, a law school national champion, and a college All-American. So we're thrilled to have her. Ria, thanks for joining. Joe, Isa, Rory, Amberlyn, Ken, Simone, what an all-star cast. I'm going to ask you to turn off your cameras, and you all should have your ballots. And I'll ask our counsel to turn on their cameras, please. All right, we're going to call the case of United States versus Bainbridge. Can I get appearances, please, starting with the government?
Yes, Your Honor. Good afternoon, Your Honor. My name is Anya Luo, and I'm joined today with my colleague, Mr. Tobin Hill.
Good afternoon, Your Honor.
Hello.
Together, we proudly represent the United States federal government.
Thank you, Ms. Luo. Defense?
Yes, Your Honor. Good afternoon, Your Honor. My name is Dana Elkuza, appearing on behalf of the defense, representing my client, Beck Bainbridge. And I'm joined by my colleague, Miss Manti Ma.
Hello, Your Honor.
Hello. Okay, thank you, counsel. Welcome. Is there anything we need to take up before we hear opening statements?
No, Your Honor. In this jurisdiction, housekeeping matters have been taken care of before trial.
Defense?
Yes, Your Honor, we agree. The defense is ready to proceed as well.
Great. Are timekeepers ready to go?
Yes, Your Honor, defense timekeeper is ready.
Excellent. All right. The government can proceed with its opening statement. I'm going to give you the full screen, so I'll have my camera off, but I'm right here. You may proceed.
Yes, Your Honor. The defendant disguised the diagnosis. It's July 1st, 2025, and the defendant, Beck Bainbridge, is furious. He's furious because she's about to lose $15 million from a contract she had signed. The terms of that deal, it's void if the fighter doesn't compete in a highly televised boxing match just 3 days away. So when the doctor tells the defendant that her fighter has a concussion and can't compete, you'll learn that the defendant didn't take no for an answer. To the defendant, it didn't matter if there was a 50% chance the concussed boxer dies fighting in the ring. Not when $50 million was riding on it. So instead, you'll learn how the defendant calls that doctor and tells them, "You better clear him to fight or you're out of a job." Then sends him a $50,000 bribe until that doctor finally gives in. 3 days later, Atlas Balboa enters the ring. And 3 minutes later, he's dead. He's dead because this defendant disguised the doctor's diagnosis. That's why we came to court today. As the United States federal government, we're bringing a criminal charge of involuntary manslaughter against the defendant, Beck Bainbridge, which means there are 2 things we have to prove. 1, that the defendant knowingly, consciously disregarded the risks that concussion posed, which 2, led to his fighter, Atlas Balboa's death. We'll prove each of these elements with 2 facts: the concussion and the cover-up. First, the concussion, because you'll hear today from a doctor about a practice 3 days before the big match, when the fighter was hit on the head and diagnosed with a concussion. You'll learn this meant the fighter couldn't compete, because doing so would put that fighter at over a 50% risk of death. And the defendant knew that. Because you'll see today an email where Dr. Liu clearly explains to the defendant the threat against Atlas Balboa's life. But you'll hear how the defendant responded with threats of his own, telling Dr. Liu over a phone call, "You better clear him to fight or you're out of a job." So second, the defendant tried to cover up that concussion. Because when threats didn't work, well, members of the jury will show you records of a $50,000 wire transfer from the defendant to that doctor, sent minutes after that phone call. And then a new email from that doctor appears in the defendant's inbox, and it says that the fighter is cleared to compete. But you'll find by the end of this trial that the defendant knew there were still deadly risks because the defendant disguised the doctor's diagnosis. Members of the jury, $50 million was how much this fight was worth to the defendant. And if it didn't happen, she wouldn't get a single penny. And it turns out that $50 million contract was worth more to the defendant than her fighter's life. That's why at the end of this trial, we'll ask you to find her guilty. Thank you.
Thank you, counsel. Defense, you can open.
Yes, Your Honor. It was the doctor's decision, and he made the wrong one. It's July 6th. A doctor sits alone in an FBI interrogation room. Just 2 days earlier, Atlas Balboa died in the center of a boxing ring. Now, the doctor who medically cleared him to fight is sitting across from federal agents. The doctor admits something no physician ever wants to admit. I cleared Atlas Balboa to fight. Now he's faced with the consequences. Now Atlas Balboa is dead. Then the agents explain what comes next. Clearing a fighter with a concussion isn't just a mistake. It could be a crime carrying years in prison. Then they offer another option. Cooperate. Tell them someone else is responsible. Instead of facing up to 20 years in prison, the doctor could receive just 6 to 12 months. So then the doctor starts thinking back to a 30-minute phone call, back to a performance bonus, and one by one, those moments begin to take on a different meaning. The phone call becomes a threat. The bonus becomes a bribe. The doctor's own decision becomes someone else's responsibility. The government has built a story that shifts the doctor's decision onto my client. Today they've charged Mr. Bainbridge with involuntary manslaughter. In order to meet that burden, they must prove beyond a reasonable doubt that she caused Atlas Balboa's death by acting with reckless disregard for human life. Meaning Beck Bainbridge knew the risks of putting Atlas Balboa in the ring and ignored it. They want to be able to do that to you because of 3 facts: the decision, the doubt, and the deal. Let's start with the decision. Before Atlas Balboa had ever stepped into that ring, only one person had the authority to determine whether he was medically fit to fight: the doctor. You'll see 2 emails. In the first, the doctor diagnoses Atlas with a concussion and says he cannot fight. Just 1 hour later, the doctor sends a second email clearing Atlas to fight. Miss Bainbridge didn't write that email. You'll learn she never signed it. Heck, you'll learn, members of the jury, that she wasn't even there. The doctor made that medical decision. When the doctor changed the diagnosis, Miss Bainbridge did what anyone without medical training would do. She relied on the judgment of the physician responsible for making it. Which brings me to my second fact: the doubt. Now, why would a doctor go from being absolutely certain about a diagnosis to changing it? The government wants you to believe the doctor changed that diagnosis because Miss Bainbridge forced it. They won't show you any evidence proving that. You'll hear about that 30-minute phone call. We'll call Miss Bainbridge herself. She'll tell you that all she asked was to make sure that Atlas was safe and to double check. You won't see any transcript of that phone call. You won't see any recording. The government will only ask you to believe the doctor's word. Now, finally, the deal. After Atlas died, the doctor admitted to changing the diagnosis and clearing Atlas to fight. Then the FBI came calling. Facing years in prison, the doctor accepted a cooperation agreement, surrendered a medical license, and now stands before you under a promise that the government will recommend just 6 to 12 months in prison. Once the doctor's own decision carried criminal consequences, there was finally a way to shift responsibility onto Beck Bainbridge. The government says Beck Bainbridge disguised the diagnosis. Members of the jury, Miss Bainbridge didn't write the diagnosis. She didn't send the emails. The doctor did. The diagnosis wasn't disguised by Beck Bainbridge. You'll learn it was changed by the doctor and the doctor alone. By the end of today's trial, we ask that you make the right decision, that you find Miss Bainbridge not guilty, because it was the doctor's decision, and she made the wrong one. Thank you.
Thank you, counsel. Government, you can call your first witness.
Yes, Your Honor. We call Dr. Sidney Liu to the stand. Good afternoon, sir. Could you please introduce yourself to the court?
Good afternoon. My name is Dr. Sidney Liu.
What do you do for a living?
Well, now I work at a 7-Eleven just outside Newark, trying to make some amends. But before, I was a ringside physician and pre-fight evaluator for the professional boxing and mixed martial arts.
Sir, why aren't you a doctor anymore?
I made a choice that caused the fighter to get killed. He had a concussion, and it was too dangerous to let him fight. But I cleared him anyway.
Why?
Beck Bainbridge. She threatened me, then transferred $50,000 for me to change my mind.
Your Honor, at this point, we ask Beck Bainbridge to turn on their camera for witness identification purposes.
Yes.
Sir, do you recognize Beck Bainbridge, the defendant, sitting in court today?
Yes, ma'am, I do. She's wearing that polka dotted, I believe it's a dress right there.
Let the record reflect Dr. Sidney Liu has successfully identified the defendant.
Record will reflect that
Sir,
the record will reflect that the witness has identified the defendant.
Sir, if the defense, Ms. Alcuza, were to claim it was actually your decision and you made the wrong one, would that be true?
Absolutely not. I mean, it would only be true if they brought in the fact that I received a bribe and I was threatened with my livelihood.
Well, sir, let's back up for a moment and get some facts straight. Are you familiar with the person Atlas Balboa?
Yes, ma'am, I am.
Who was he?
He was a fighter I cleared. As a medical professional, I was responsible for his health in the lead up to the fight, before and during the match. This meant being present at all of the practices and fights.
How do you know the defendant?
I've worked under Bainbridge Boxing since, I believe, about 2023 as a medical director. I'm certified in concussion management. I've been licensed to practice medicine for about 15 years now.
And so what's your role as a medical director?
Well, I typically evaluate fighters on a fighter timeline, typically 30 days before the fight, 7 days before the fight, 3 days before the fight, and 2 hours before the fight.
Well, let's talk about those pre-fight medical evaluations you performed for Atlas Balboa. What did these include?
The first 3 of the 4 checkups included a physical examination with vision, cognitive and cardiovascular evaluation, and a blood test. The final checkup is just 2 hours before the fight, so it's quicker to check for more serious injuries at that time.
Did you find any issues at any of these checkups?
No. 30 days, a week before, Atlas was healthy and not had some worrisome injuries. The issue came on July 1st, 3 days before the fight.
Your Honor, let the record reflect the prosecution is screen sharing a visual timeline demonstrative, already shown to opposing counsel prior to trial. Sir, what happened on July 1st?
Well, Atlas had a sparring session at around 7:15 a.m. A left hook was landed on the right side of Atlas's head. I was watching and rushed on the ring to see why he had collapsed.
What happened to Atlas?
He had nausea, blurred vision, couldn't walk in a straight line. He didn't even know what day of the week it was. I performed the standard methods, and based on everything I saw, I thought he had a concussion. Later, it was confirmed from the autopsy report that he did suffer one.
Did you let the defendant know about this concussion?
Absolutely. I sent them an email right after that.
Your Honor, for the record, the prosecution is sharing Exhibit 6. Sir, do you recognize this?
Yes, this is the email I sent at 9:14 a.m.
Does it look fair and accurate?
Yes, ma'am.
The government offers Exhibit 6.
Any objections?
Yes, Your Honor. As to 702, may I be heard?
Yes.
Your Honor, this email that's being displayed here includes the doctor's own expert conclusion and opinion regarding Atlas Balboa's health and how they had a concussion and could face second impact syndrome. Opposing counsel has not laid the foundation that this expert has reliably applied any sorts of methods to the facts of the case, or that those methods are used in their profession commonly, Your Honor. Therefore, under 702, this cannot be admitted.
Reply?
Yes, Your Honor. We're not offering any of the contents in the emails for its truth purposes to show that these conclusions indeed are true. Instead, we're offering this email solely for the purpose to show the defendant had notice that he read the lines of this email and he knew Atlas Balboa had a concussion that his medical practitioner would not recommend to him to compete. Your Honor, the truth value of these statements have already been elicited and have already been confirmed by the autopsy report that Dr. Liu mentioned previously.
I agree. The objection is overruled. Exhibit 6 is admitted.
Yes, Your Honor. Sir, in this email, what did you write about the fighter's condition?
Well, basically, he wouldn't be able to fight. No doctor should clear him. There'd be too much risk that he'd suffer second impact syndrome, or SIS.
SIS? What is that?
Basically, it's when somebody suffers a second head injury before the prior concussion has healed practically. It triggers severe swelling, increased pressure, and has a mortality rate of around 50%.
So when you told the defendant his fighter couldn't compete, how did she respond?
She called me just minutes after I sent the email at 9:23.
Let's see if the defendant tried to disguise her diagnosis over that call. What happened?
She threatened me. She told me if I don't clear him to fight, you will never work in this business again. When I didn't give in, she told me she'd pay me if I changed my diagnosis.
Did you change your diagnosis?
Yeah, I was forced to. I sent another email after that call around, I believe it was around 10:14. This time St. Atlas was cleared to fight. It wasn't true, of course.
Why would you clear Atlas Balboa?
She would send me money. They also threatened to destroy my career.
Sir, I want to be clear. Did you let Atlas Balboa compete because you thought you made a mistake?
No, I let Atlas compete because I felt threatened and the bribe.
Did you let him compete because you felt pressured by a $50 million match?
By a $50 million match, no, I let him compete because Beck threatened me.
Sir, would you recognize a copy of the wire transfer, the $50,000?
Yes, ma'am, I would.
Your Honor, for the record, I'm showing Exhibit 8. Sir, is this the first wire transfer you've ever received?
No, I get them regularly.
Does this look like a fair and accurate copy?
Yes, ma'am.
The government offers Exhibit 8.
Yes, Your Honor. Objection as to Rule 902, lack of authenticity, if I may be heard.
Go ahead.
Your Honor, we've heard no testimony or foundation laid about any qualified witness or certification of anything complying with Rule 902 in regards to whether or not this bank is real or whether or not this wire transfer is authenticated, Your Honor.
Response?
Yes, Your Honor. If opposing counsel is referring to Rule 8036, we believe Dr. Liu is considered a qualified custodian as he is the one who received this wire transfer. And previously, he just answered my question that this isn't the first wire transfer he's ever received, and this looks fair and accurate to him.
Last word, defense?
Yes, Your Honor. Not only under 8036, but also under 902, there would be need to have had authentication laid as to whether or not this bank is even real, Your Honor, even though this witness had received the money and can testify as to how much money they received. To admit this into evidence, the bank would need to be authenticated, Your Honor.
Response to that, Your Honor?
Okay.
Your Honor, it seems like opposing counsel's arguments are going towards weight, not admissibility. If they have arguments to believe that this bank isn't real, they're free to take that up on cross-examination, but that does not affect how this Dr. Liu is qualified to be talking about his own records.
Okay. Thank you both. I'm going to admit Exhibit 8.
Yes,
Yes.
Your Honor.
So, sir, looking at this wire transfer, what does it show you?
The defendant sent me around $50,000.
When was the money sent?
3 minutes after I changed my diagnosis.
Well, finally, sir, let's talk about July 4th, the day of the big boxing match. What happened that day?
Atlas Balboa competed. Just 3 minutes in, he was hit on the right side of his face, the same place where he was concussed. Then he died. I feel so terrible, ashamed. I could only think about my career, but now somebody died.
Dr. Liu, would you have cleared him if it weren't for that $50,000 payment from the defendant?
No, no, but I couldn't stop thinking about all the money, what I could do with it, and I thought the risk might be worth the reward.
So why are you in court today?
I'm in court today because I feel guilty in my role in this. Clearing him to fight, I'm testifying as an agreement with the government for a reduced sentence. I agreed to testify truthfully against Beck Bainbridge today.
Well, thank you for your time today, Doctor. Your Honor, we have nothing further.
Okay. Defense counsel, you can.
Cross, Your Honor.
Yes, you go ahead.
Yes, Your Honor. Good afternoon, Mr. Liu.
Good afternoon.
Let's start by talking about who actually made the medical decision to put Atlas Balboa in that ring. When Atlas got injured, you were the only one in the gym that day, correct?
Yes, ma'am.
And on July 1st, that same day, you actually sent an email to Miss Bainbridge medically clearing Atlas to fight.
Yes, ma'am, that's correct.
You'd recognize that email if I showed it to you?
Yes, ma'am, I would.
Your Honor, let the record reflect that we're going to be screen sharing Exhibit 7. Does this look fair and accurate, sir?
Yes, ma'am, I believe it does.
Your Honor, permission to admit Exhibit 7 into evidence?
The version we'll admit doesn't have highlights, but you can certainly use the highlighted version when you display it to the jury. So Exhibit 7 is admitted.
Yes, Your Honor. Sir, let's make this clear. This is the last email regarding Atlas Balboa that you ever sent to Miss Bainbridge, right?
Yes, ma'am, that's correct.
And you titled this email Atlas Balboa Medical Clearance?
Yes, ma'am, that's the subject line.
And on this email you write, I have determined that Atlas remains medically cleared to fight. True?
Yes, ma'am, that's true.
You don't mention second impact syndrome?
No, ma'am, I did not.
You don't mention a concussion?
No, ma'am.
These were your last words to her before the championship fight.
Yes, ma'am, I believe that's correct.
Now, sir, according to you, you only sent that second clearance email abandoning your diagnosis because you were bribed during a phone call?
Yes, that's exactly what happened.
Let's make this clear, sir. You don't have any recording of that call?
No, ma'am.
You don't have a transcript of that call?
No, ma'am.
So I want to make something very clear to the members of the jury. We don't have anything except your word to prove that Miss Bainbridge said the things you claimed she said.
Well, to be clear, you also have Miss Bainbridge's word if she tells the truth.
Sir, Miss Bainbridge hasn't come and taken the stand yet. The only person to your knowledge who can tell us that story is you.
Yes, ma'am, I guess that's correct.
So let's see why you changed your diagnosis. Sir, you're aware as a medical doctor that specializes in concussions that concussion symptoms can fluctuate.
Yes, ma'am, that's correct.
Patients can temporarily appear feeling better within a short amount of time.
Yes, ma'am.
You testify that that phone call ended and then about 20 minutes later, you sent a second email.
Yes, ma'am, I sent a second email.
So there was roughly a 20-minute gap between the end of that phone call and the time you press send.
Yes, ma'am.
So now you're telling this jury that in those 20 minutes you never re-examined Atlas?
No, ma'am. I felt threatened. I just sent the other email.
Sir, despite there being a 20-minute gap that no one knows what you did with, you're still saying you never re-examined them.
No, ma'am.
Mr. Liu, tell me something. How much is your salary?
Well, at the 7-Eleven, it's about $15 an hour.
Sir, as a medical director, how much do you make per year?
Uh, I believe my last year at Bainbridge Boxing LLC, I was making about $220,000 a year.
Now, that $50,000 bribe that you claim Miss Bainbridge gave you, that's less than 25% of your salary.
Well, I'm a doctor, not a mathematician, but I think that's correct.
You're here telling us today that you were willing to risk your medical license that you spent 15 years working for a payment less than 25% of your salary?
Yes, ma'am, but you're forgetting the fact that he also threatened to blacklist me from boxing.
All right, sir. Let's talk about why you're making those exact claims today. Let's set the scene. You're being charged with involuntary manslaughter.
Okay?
Police begin asking you questions, right?
Mm-hmm.
They tell you that your charge carries up to 20 years in prison.
Well, they would say that's the maximum. I've only faced it about 3 years, actually.
Well, yet, then they give you another option.
Okay?
Sir, instead of up to 20 years, you could only have to serve 6 months, yes?
Yes, ma'am, that is the deal they gave me.
That's only if you take the stand today and testify that Miss Bainbridge forced you to commit your crime.
Well, actually, I got testified truthfully against Beck Bainbridge, and that is the truth, that they forced me.
Thank you, sir. And no further questions, Your Honor.
Is there a redirect examination of this witness?
No, Your Honor. Can Dr. Liu be excused?
Yes, Dr. Liu is excused.
With that, the government rests its case in chief.
Thank you, counsel. Does the defense wish to put on a case?
Yes, Your Honor. We'd like to call Miss Beck Bainbridge to the stand.
Go ahead.
Good afternoon, Miss Bainbridge.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Yes, ma'am. My name is Beck Bainbridge.
What do you do for a living, Miss Bainbridge?
Well, I have been and still am the owner and CEO of Bainbridge Boxing LLC. It is a boxing promoting company.
Miss Bainbridge, have you been present throughout today's entire trial?
Yes, ma'am, I have.
Have you heard the government claim that you disguised the diagnosis?
Yes, ma'am, I heard all of that, whatever that means.
Is that true?
No, ma'am. I didn't disguise no diagnosis. And I'm not a doctor, so I didn't diagnose anyone.
So, ma'am, let's just make this clear to the members of the jury. Did you have any financial interest in the July 4th fight?
Well, yeah, it was a big fight. We had a contract going with Donna King Productions and Netflix, and both me and Mr. Balboa, God bless his heart, may he rest, we're both going to get about $25 million apiece.
Ma'am, even though you were going to get $25 million, would you ever put an 8-figure contract ahead of one of your fighters' lives?
Objection, Your Honor. Under Rule 1002, best evidence, if I may be heard.
Yeah, please explain.
Your Honor, we believe the contract Ms. Alcuza is referring to right now is Exhibit 13. And pursuant to 1002, the most accurate, reliable evidence is always the original document, so it must be admitted before she dives more into the details of that contract.
Response?
If I may, Your Honor. Yes, Your Honor. We're not going to dive into any of the details of the contract. What Miss Bainbridge is simply saying is that she was going to gain $25 million from that fight. Opposing counsel has already said repeatedly that there was a payout in relation to this case and how much Miss Bainbridge was going to get. We're not going to detail the consequences of that contract or what could happen if she wasn't going to get that payment. We're simply just saying the amount here, Your Honor.
Response to that?
Yes.
Your Honor, by Ms. Alcuza specifically using the word contract and mentioning the $50 million in the contract, and furthermore, how Ms. Bainbridge is gaining $25 million, half of that contract, those are all details that only come from Exhibit 13. So we'd ask that she enter it at this time.
Response, Your Honor?
No, the objection's overruled.
Yes, Your
Yes.
Honor.
Miss Bainbridge, would you ever put an 8-figure contract ahead of one of your fighters' lives?
No, ma'am. The lives and the safety of my boxers is to the utmost importance. And you can't put a monetary value on a human life.
So, ma'am, let's go back to July 1st and talk about the decision that started this case. What happened that day?
Well, on July 1st, I was notified by my former medical director, Mr. Sidney Liu, and he told me that one of my boxers, Atlas Balboa, had been injured.
What did you do after reading it?
Well, I read his email and I was concerned, to say the most. I immediately called him up on the phone and we had a conversation.
Miss Bainbridge, we've heard Mr. Liu's version of that phone call. Let's let the jury hear yours. Why did you call Mr. Liu?
I was concerned, very concerned, and worried about the well-being of Mr. Balboa. You know, reading that email, it frightened me. So I asked him to please re-examine and recheck his diagnosis. I knew that if Mr. Balboa was really injured, then we'd have to pull him from the fight. And this was a big opportunity for Atlas. But at the end of the day, his safety mattered most, and I would have had no problem pulling him.
Ma'am, during that phone call, did you ever tell Mr. Liu to change his diagnosis?
No, ma'am, I did not.
Did you ever ask Mr. Liu to medically clear Atlas Balboa?
Not at all. I actually made it very clear that he should not clear Mr. Balboa, especially if it wasn't safe.
Then what did you ask Mr. Liu to do?
All I asked him was to re-examine Mr. Balboa and make sure his diagnosis was correct.
So after that conversation, did Mr. Liu contact you again?
Yes, ma'am, he did. He sent me another email.
Would you recognize that second email?
Yes, I would.
Your Honor, let the record reflect that we're going to screen share Exhibit 7, which has also already been admitted. Miss Bainbridge, what did Mr. Liu tell you in the second email?
In this email, Mr. Liu, he told me that Atlas Balboa was clear to fight and that the previous symptoms from the last email were inconclusive.
Let's talk about Atlas Balboa himself. How did you know him?
He was a fighter of mine. He was signed to Bainbridge Boxing last year, and he was a new up-and-coming fighter, but I saw real potential in the kid. I mean, he had the spirit, the determination. He had everything a boxer needed. And when I saw him, I said, I want him in Bainbridge Boxing. Because I knew he could have swept that heavyweight champion.
Miss Bainbridge, did you ever communicate with Atlas Balboa before the fight?
Yes, ma'am, I did.
Would you recognize those messages today?
Yes, I would.
Your Honor, stating for the record, we're going to be screen sharing Exhibit 10. Ma'am, does this look fair and accurate?
Yes, ma'am, it does. Everything looks clear.
Your Honor, permission to admit Exhibit 10 into evidence?
Any objections?
No objections, Your Honor.
10 is admitted.
Miss Bainbridge, what was Atlas telling you in these text messages?
Well, on July 2nd, he told me that ever since his sparring session, his head hadn't been right. And I told him, well, the doc says you're clear. Because this was after Mr. Liu had emailed me and told me he was clear. And then on July 4th, he told me that he had a headache still. And I referenced him to Dr. Liu. After all, Dr. Liu's the doctor. And he had an examination later that day. So I said, if the doctor says you're clear, you're clear. And he was ready to fight.
So, Miss Bainbridge, let's talk about what you knew on July 4th. Did you know that Atlas Balboa was still suffering from a concussion?
No, ma'am. If I had known he was suffering from a concussion in the first place, I would have never let him step foot into that ring.
Did you know Mr. Liu's second medical clearance was false?
No, I had no idea. I trusted Dr. Liu. You know, he had been working with me for the past 3 years, and I would have never expected something like this to come out of him.
We've also heard testimony that the government says you bribed Mr. Liu. Is that true?
That is not true. I did not bribe Mr. Liu.
So then why did you send the $50,000 payment?
Because where I'm from, Mississippi, and the way that I was raised, my mother always taught me to be grateful, appreciative, and especially thankful. And you know, after Mr. Liu went that extra mile, or at least I thought he did, you know, I know testing like that can be expensive and time consuming. And I wanted to show my appreciation.
Miss Bainbridge, let's just make it clear for the members of the jury who actually made the decisions in today's case. Let the record reflect we're going to be screen sharing a demonstrative that has already been shown to opposing counsel. Ma'am, after Atlas was injured, who performed the medical examination?
That would be Mr. Liu. He was the medical examiner at the time, so it was his responsibility.
Who made the medical diagnosis?
There would once again be Mr. Liu, the doctor.
Who decided whether Atlas was medically cleared to compete?
Once again, ma'am, that would be Mr. Liu. He is the doctor in the situation. I have no medical training, and I have no authority in that jurisdiction.
Miss Bainbridge, did you interfere with any part of that process?
No, ma'am, I did not. I mean, I asked him to recheck his diagnosis, but that's about it. I'm no doctor. I don't have any medical training. I don't know much about being a doctor, so I left that all up to Mr. Liu.
Thank you, ma'am. No further questions, Your Honor.
Thank you, counsel. Is there a cross-examination?
Yes, Your Honor.
You can proceed.
Good afternoon, Miss Bainbridge.
Good afternoon.
You said something a few minutes ago, so important, I actually wrote it down. You said you trusted Dr. Liu.
Yes, ma'am, I did. I had been working with him for the past 3 years.
But ma'am, let's be clear. That trust was conditional.
I'm sorry. I would like, can you clarify, ma'am, when you mean conditional?
Sure, that trust was conditional because when the doctor said your fighter couldn't compete, you called him instantly.
Well, I still trusted Dr. Liu when he sent that first diagnosis. I trusted him so much, that's why I called him in the first place. Wanted to make sure that everything was all right.
You called him for 30 minutes.
Yes, ma'am. I'm not really savvy with all this medical stuff, so he had to break things down for me, all the tests and whatnot.
All right, well, now, just a moment ago, you actually showed us a timeline on screen. Let's take another look at it. Because, ma'am, this timeline is actually missing a few steps.
Is it, ma'am? You tell me.
After the doctor made their diagnosis, you called them.
Yeah, but he made his final diagnosis as well.
And after the doctor cleared him, you wired $50,000. Sure.
Yeah, I did. I'm not hiding that. That went through my bank. It was nothing to hide.
Well, Your Honor, let's see if you tried to disguise a diagnosis during that 30-minute phone call. Your Honor, for the record, the prosecution is sharing Exhibit 6. Ma'am, you read this email.
Yes, ma'am, I did.
You knew Atlas Balboa had a headache.
I knew he had a headache according to the email, yes.
Dizziness, nausea, blurred vision, all these symptoms.
Yes, everything that was listed out in the email, which really concerned me.
You knew it was a concussion.
I didn't know for sure. That's why I called Dr. Liu and asked him to recheck his diagnosis.
Objection, Your Honor, as to Rule 403, may I be heard?
Yes, before you explain, can you tell me which part of the answer you're objecting to is unduly prejudicial?
Yes, Your Honor. Actually, as to Rule 403, more misleading regarding this line of questioning that's specifically asking Miss Bainbridge what she knew on July 4th in regards to the concussion and secondary impact syndrome and the long list of symptoms.
Okay, why do you believe that is substantially more misleading than it is probative?
Yes, Your Honor, because this line of questioning creates a misleading impression by focusing solely on Mr. Liu's initial medical opinion while completely omitting the subsequent medical clearance. Your Honor, opposing counsel is questioning Miss Bainbridge about what was in Mr. Liu's initial medical opinion, that Atlas had a concussion and faced the risk of SIS, but that questioning once again completely omits the later issued second medical opinion medically clearing Atlas to fight.
Government?
Yes, Your Honor. 403 has an extremely high bar. It must be substantially more prejudicial than probative. But, Your Honor, in this case, there is absolutely no prejudicial value. The probative value this brings, it demonstrates that Miss Bainbridge knew Atlas Balboa had all these symptoms based off the doctor's first email. And by reading that email, she knew he had a concussion. We're not claiming that's the only thing she read. We actually referred to that second email several times where the doctor did end up changing their mind. However, it's not prejudicial at all to show at the time Miss Bainbridge read about these symptoms and knew they existed.
The objection's
Respond,
overruled.
Your Honor.
The objection's
Yes,
overruled.
Your Honor.
Go ahead.
Yes, Your Honor. So, ma'am, still looking at this email, you knew if Atlas Balboa fought with that concussion, there'd be over a 50% chance he dies.
Well, that's if he had a concussion. Back then, I had no idea if he had one. And Dr. Liu eventually he disregarded this entire diagnosis.
All right, so you're saying that you didn't threaten the doctor, but after your phone call, the doctor changed his mind.
Well, yeah. I asked him to re-examine Mr. Balboa, and I was under the impression that after re-examining him, he figured out that his first diagnosis was wrong.
So all those symptoms, headache, dizziness, difficulty concentrating, they just vanished?
Well, yeah, I'm no doctor. I don't know exactly all the tests he did, even though he spent so long talking to me about it, but I trusted the doctor. He made his decision, and he cleared Atlas to fight.
Okay, so 3 minutes after all those symptoms just vanished, you bribed the doctor.
No, ma'am. I did not bribe the doctor.
All right, ma'am. You sent a large bonus.
I sent him a bonus, yes, a token of my appreciation. You could call it Southern hospitality.
Your Southern hospitality was more than 20% of the doctor's salary.
That's correct, but I don't want to toot my own horn, but I am a wealthy woman, and my company is also very wealthy.
And your wealthy company's average is 5% for bonuses.
Usually, but this was a special occasion. I was thankful that Mr. Liu went the extra mile and re-examined Balboa, or at least I thought he did.
Hang on, you just said this bonus was a special occasion. Let's see what made that occasion so special. Because, ma'am, Dr. Liu's second email cleared Atlas Balboa for a very important fight.
Yeah, it was a very important fight, especially for Atlas. This was his biggest fight as a new up-and-coming boxer. This was his big break in the boxing industry.
It was also a big fight for your company.
Yeah, I would say so. It was one of our biggest contracts so far.
Your Honor, for the record, the prosecution is screen sharing Exhibit 13. Ma'am, you recognize this contract?
Yes, ma'am. This is the contract between me, Donna King Productions, and Netflix.
When you put your signature at the bottom, you believe this contract to be true?
Yes, ma'am.
Your Honor, the government offers Exhibit 13.
Any objections?
Yes, Your Honor, as to 802 hearsay.
Response?
Yes, Your Honor, this is admissible under Rule 801D2B, as these are statements adopted and believed to be true from the opposing party, Ms. Bainbridge. This is confirmed by Beck Bainbridge's signature at the bottom of the document, and just moments ago, the defendant agreed she believed this contract to be true when she signed it.
Brief reply?
Yes, Your Honor. Under this exception, or rather, Your Honor, still, we would have to be taking these exact statements for the truth, as they are out of court statements being used for the truth, such as the specific withdrawal or cancellation policy, and certain facts within this document, Your Honor.
Okay. I agree with the government. This document is admitted as Exhibit 13.
Yes,
Your
Your
Honor.
Honor.
So, ma'am, looking at this contract, it says $50 million paid to Bainbridge for this fight.
Yes, and we were going to cut that in half, and half of it would go to Mr. Balboa.
But this was still the biggest contract in your company's history.
Yes, ma'am. We've had some close to, but this was the biggest.
But, ma'am, 2 lines down, it says if Atlas Balboa, your fighter, doesn't compete, this contract goes away.
That's correct.
You won't get a penny of those $50 million.
That's correct, but like I said, there's no monetary value to a human life, and had I known Mr. Balboa was injured, I would have pulled him from the fight, no hesitation.
Well, just looking at the monetary value of this contract, you wouldn't get a single penny if your fighter didn't compete.
No, ma'am, and given the situation, if I'd known he was injured, farewell.
Well, thank you for your time today, Miss Bainbridge. Your Honor, I have nothing further.
Anything else for this witness?
Yes, Your Honor, a redirect.
Go ahead.
Miss Bainbridge, we heard a lot that you were expected to receive $25 million. After you received that money, what did you do with it?
Well, after I received that money, I donated about half of it to a brain injury charity, and I'm putting the other half into my company, bettering things, hiring more people, and hopefully I can hire better medical staff.
Thank you, ma'am. No further questions, Your Honor.
Any additional questions by the government?
No, Your Honor.
All right, the witness may step down. Okay. Ms. Lua, I should turn to the defense, excuse me. Defense, do you have any additional witnesses?
No, Your Honor, we rest our case in chief.
Okay. Government, would you benefit from 60 seconds to prepare your closing argument? I know I'm not supposed to give you a break, but I don't think it'll get appealed.
We'd be happy with 60 seconds, Your Honor.
Okay. So we'll each take a minute and we'll come back on the screen and we'll hear closing from the government. Judges, in case you need it, I'm putting the ballot in the chat. All right, let's hear closing arguments. Any time you don't use is reserved for rebuttal. You may proceed.
Yes, Your Honor. The defendant disguised the diagnosis. $50 million. 50 million reasons to take a risk. And members of the jury, you learned today that the defendant took a risk by sacrificing Atlas Balboa's life. $50,000. And that is a bribe. A bribe that the defendant sent Dr. Liu to get his fighter in the ring. After knowing Atlas Balboa had a concussion, after knowing his head was killing him, after knowing fighting that day might get him killed, the defendant chose to disguise the doctor's diagnosis. Now, Ms. Alcuza said today it was the doctor's decision and he made the wrong one. But members of the jury, you learned today the doctor didn't have a decision to make. It was the defendant who decided to threaten to bribe that doctor and to disguise their diagnosis. It was the defendant who made the wrong decision. That's why we came to court today. As the United States federal government, we're bringing the same criminal charge of involuntary manslaughter against the defendant, Beck Bainbridge. Now, as we explained during the beginning of trial, this meant there were two things we had to prove today. One, that the defendant knew there were deadly risks, but because he consciously chose to ignore them, two, his fighter was killed. We proved this beyond a reasonable doubt today with the same two facts: the concussion and the cover-up. First, the concussion. You heard today from the doctor about how his fighter sustained a concussion 3 days before the big match. And we showed you the email the doctor sent to the defendant telling them the concussion meant the fighter couldn't compete because doing so would put that fighter at over a 50% risk of death. The defendant read that email. He knew the risks, but chose to ignore the threats to Atlas Balboa's life. So second, the defendant covered up that concussion. Because you learned today about a phone call where the defendant threatened the doctor, then sent a $50,000 bribe. Well, the defendant got what he wanted. The doctor sent a second email clearing the fighter to compete. But 3 minutes after that fighter takes the ring, he's dead. We met our burden today because the defendant disguised the doctor's diagnosis. $50 million. That's how much money the fighter's match was worth to the defendant. And today, the defendant was forced to confront a contract that gave his company those $50 million. But the only catch was, if her fighter didn't compete that day, the defendant wouldn't get a single penny. Now, earlier today, she tried to bring up how she donated half of the company's earnings. But that doesn't mean the defendant didn't care about the money. Bainbridge Boxing has been preparing for a criminal trial, and they'd rather lose some money than lose this case. In fact, members of the jury, the defendant is still keeping $12.5 million that she wouldn't have gotten if her fighter didn't compete that day. Now, earlier today, during opening statements, Ms. Alcuza talked about decision, doubt, and deal. Let's go through those one by one. First, she talked about a decision and how the defendant actually had no idea. But members of the jury, we showed you today the email the doctor wrote the defendant. How she spent an entire paragraph explaining the symptoms. Dizziness, nausea, blurred vision, couldn't see straight, couldn't walk in a straight line, couldn't even remember the day of the big match. He ends this email by saying there is over a 50% chance of death if his fighter does end up competing. And not only did the defendant read this email, but he also listened on a phone call where the doctor once again explains all of these risks. But then out of the blue, the doctor sends a new email that says in one line, the fighter's clear, all those symptoms, they've vanished. Atlas Balboa's head doesn't hurt anymore. The defendant didn't send any follow-up emails. He didn't call the doctor again with concerns because he knew it was a lie. Instead, she transferred $50,000. Second, Ms. Alcuza talked about the doubts. She talked a lot about a phone call today. And sure, she can say that because no transcript of the phone call exists, we don't know what happened. But that's not true. Because before that phone call, Dr. Liu was confident it was a concussion. But now the defense wants you to believe after a 30-minute phone call with the defendant, the doctor suddenly decides those symptoms vanish. Atlas Balboa is cleared to fight. The concussion's gone. The only reason why that doctor would change their mind is if they were threatened and they were bribed. And we showed you records of those bribes today. As members of the jury, the defendant can try to call that bank transaction a bonus. They can try to call it a little token of appreciation. But is that reasonable? Because the defendant admitted today on cross-examination a typical bonus is 5% of the employee's salary. This bonus, it was a special bonus because it was worth 20%, given at the end of June, 3 minutes after the doctor changed their diagnosis. 3 minutes after the doctor cleared their fire to compete. That is not a bonus. That is a bribe. And so finally, something that's come up a lot today is Dr. Liu's credibility. He's on a plea deal. But I want to be clear today, we're not defending the doctor. We're not calling him a saint. He accepted a bribe, and for that, he's given up his medical license, and he's going to spend half a year in jail. But if that doctor doesn't tell the truth today, he's going to prison for 20 years. The defendant disguised the diagnosis. And because of that, somebody died. Somebody who was just 20 years old with a full life ahead of him, that somebody was Atlas Balboa. And he deserved better than dying in that ring. Now, nothing we do or say today can change that, but we can bring comfort to his family. And we can make sure something like this never happens again by holding the right person accountable. Find the defendant guilty. Thank you.
Thank you, counsel. Defense, you can close.
Yes, Your Honor. It was the doctor's decision, and he made the wrong one. Have you ever worn glasses? I'm sure we all have at some point. When you take them off, things tend to get blurry. Members of the jury, when a picture is blurry, you need to squint, fill in the missing pieces, and convince yourself that you can see what is not really there. The government's case is blurry. They're asking you to fill in the gaps with assumptions based on the story they're telling you, not the truth. You can't rest on a blurry picture. You have to rest on proof beyond a reasonable doubt. And Miss Luo just got up here and told you that the defendant disguised the diagnosis, and something stood out to me. She chose the word disguised. Members of the jury, you can't disguise something you don't own. You can't disguise someone else's handwriting. You can't disguise someone else's signature, and you certainly can't disguise someone else's medical diagnosis. The diagnosis wasn't disguised. It was reconsidered. The government is asking you to take the doctor's decision and pin it on someone who wasn't qualified to make it. Members of the jury, earlier today I came up here and I told you that this case comes down to three things: the decision, the doubt, and the deal. Now, starting with the decision, the government spent so much of this trial discussing the doctor's first email. Miss Lowe came up here and just told you about multiple symptoms and a concussion and SIS that the defendant, that Miss Bainbridge, was warned of. But this case is not simply about what Miss Bainbridge learned at 9:14 on the morning of July 1st. It's about what Miss Bainbridge understood when Atlas Balboa entered the ring on July 4th. And by then, the doctor's medical opinion had changed. The doctor wrote the first email diagnosing Atlas with a concussion. The doctor also wrote the second email declaring that Atlas remained medically clear to fight. Miss Bainbridge did not conduct either examination. She didn't perform any testing. Heck, she wasn't even there at the gym when Atlas was murdered, or rather injured. Those were medical decisions. Miss Bainbridge isn't a doctor. In fact, she told you why companies hire medical directors, because promoters are not qualified to diagnose concussions or determine whether a fighter is medically safe. She was taught to trust the professionals hired to make those decisions. It's not reckless disregard. That's reliance on a medical professional. The government must prove that Miss Bainbridge was aware Atlas still faced serious risk of death or serious bodily harm and consciously ignored that risk. Members of the jury, after the second email, Miss Bainbridge didn't believe the risk still existed. The doctor, the only person qualified to make that determination, had told her otherwise. Now consider the doubt. The government calls the $50,000 payment a bribe, but look at what the document itself says. Bonus. Miss Bainbridge told you that it was a bonus. To prove otherwise, the government gave you one person's story, the doctor's. That story supposedly begins during one private phone call. Yet, members of the jury, you learned today that there's no recording of that conversation. There's no transcript. There's no independent witness who heard what was said. There are only two competing accounts. And the government asked you to accept the doctor's account beyond a reasonable doubt. Miss Bainbridge told you what he actually said. Please double check your diagnosis. Don't clear him to fight unless it's safe. Nothing is more important than safety. You saw the actual text messages, the conversation between Miss Bainbridge and Atlas Balboa. You never saw anywhere where she said, "You're fighting whether you like it or not," or "clear him anyway." Miss Liu kept suggesting that Miss Bainbridge got $25 million and that she only cared about money. But you heard that she didn't even keep the proceedings after this tragedy. She gave the money to Atlas's family and to a brain injury charity. That doesn't erase what happened, but it shows that the government's entire case regarding greed doesn't even exist. You also saw the messages between Miss Bainbridge and Atlas. And once again, she never dismissed Atlas's concerns. She didn't even know that he was still suffering from a concussion on the day of July 4th. The government repeatedly turned to the first email as proof that Miss Bainbridge knew Atlas was in danger. That's only half the story. Yes, Miss Bainbridge read the initial diagnosis. She acknowledged it. She called the doctor and asked that it be checked again. Then the doctor issued a new medical opinion. The question is not whether Miss Bainbridge ever learned of the first diagnosis. The question is whether on July 4th, if she knew that Atlas was still concussed and disregarded that danger. They never proved that. There's also another unexplained part of this story. The call ended approximately 20 minutes before the doctor sent the second email. The doctor now claims that there was no re-examination that occurred, but no one was with the doctor during those 20 minutes. No one saw what the doctor did. You heard that concussion symptoms may fluctuate and that a patient may temporarily appear improved. Miss Bainbridge believed the doctor had taken another look and corrected the original diagnosis. The government hasn't eliminated that reasonable explanation. There was also something else that the doctor said that caught my attention, and I actually wrote it down. When I asked him, who else is able to confirm the story you're telling us today, I wrote it down here, and he said, the only person is me. That's what the government's case rests on. The story of one witness who's here on a plea deal and whose future of freedom depends on his testimony against Miss Bainbridge today. Brings us to the deal. Not the Netflix agreement, not the deal government keeps talking about, not the alleged bribe. The deal that brought the doctor into this courtroom today. After Atlas fought, Atlas died. The doctor changed the diagnosis. And then the doctor became the subject of a federal criminal investigation and faced the possibility of spending 20 years in prison. Then the government offered another option. Cooperate, testify against Miss Bainbridge. You'll only get 6 to 12 months. From as much as 20 years to as little as 6 months. The doctor accepted that agreement and is testifying under it today. That gives you an extraordinarily important reason to question the doctor's story that he's telling you. When someone's drowning, they'll reach for anything that floats. Let's look at what the government has to prove to you today. First, did the government prove beyond a reasonable doubt that Miss Bainbridge knew Atlas still faced a risk of death or injury? The answer is no. Miss Bainbridge relied on the physician responsible for making that determination. The doctor changed the diagnosis and medically cleared Atlas. And Miss Bainbridge believed Atlas had been re-examined and determined safe to flight. Second, did the government prove that Miss Bainbridge consciously disregarded a risk she knew still existed? Again, no. There's no proof that Miss Bainbridge ordered that doctor to clear Atlas regardless of his condition. No recording says it, no text says it. Miss Bainbridge's own words were clear. Do not clear Atlas unless it's safe. Now third, did the government prove its case beyond a reasonable doubt? Absolutely not. Members of the jury, Miss Liu is requiring you to fill in the gaps. Assume that what happened during a private call, disregard the doctor's second medical clearance, and accept the account of a witness whose sentence depends on cooperation. That's not proof beyond a reasonable doubt. That's the blurry picture the government wants you to complete for it. You don't have to squint. You don't have to guess. The answer is right in front of you if you just pick up the glasses. The decision belonged to the doctor. The doubt remains because the government never proved that Miss Bainbridge knew Atlas was still in danger, and the deal gave the doctor a powerful reason to shift the responsibility onto Miss Bainbridge. In just a second, you'll receive this verdict form, and on it, we ask you to make the right decision, to find Miss Bainbridge not guilty, because it was the doctor's decision, and he made the wrong one. Thank you.
Thank you, counsel. Rebuttal argument?
Yes, Your Honor. Ms. Alcuza keeps denying threats or bribes ever happened. But members of the jury, ask yourselves, why? Because why would the doctor ever change their diagnosis? If they weren't threatened or bribed or pressured by the defendant, why would they ever clear an injured, concussed boxer to fight? Why, when clearing them, meant risking not only their medical license, but that patient's life? No reasonable doctor would do that, not unless they were forced to. And we do have a burden today, members of the jury. But reasonable doubt, it has to be reasonable. It is not reasonable to believe this doctor changed her diagnosis on her own because she received $50,000 just 3 minutes after. It's not reasonable to say this defendant had no idea about the concussion, not when the doctor explained all those symptoms in an email. And it's not reasonable to say Dr. Liu is trapped into blaming my client as her way out? Because the defendant trapped the doctor with those threats, those bribes, and blaming her today is the defendant's way out. Their story is just not reasonable. It's blurry. It doesn't make sense. So, members of the jury, let's put our glasses on. And suddenly, this case is so much more clear. Because the doctor, the defendant, disguised the doctor's diagnosis. Find him guilty. Thank you.
Thank you, counsel. This matter is submitted to the jury. Jurors, you can begin submitting your ballots. I'm going to have all the ballots. We'll do feedback. And I'll tell you in advance, the way we'll do feedback is I'll ask each juror to name their favorite part of each of trial for each of the two lawyers. Favorite moment for each of the two lawyers. And you don't need to worry about the witness scores. Those don't count for the determining who wins. All right, we have all the ballots. I'll ask our judges to come on screen and our two advocates. Can we give Dana and Anya a round of applause? Nicely done. Uh, Anya, tell everybody where you go to school.
Oak Park High School.
And Dana?
I go to Yorba Linda High School.
But what they're not telling you is that they're both part of the same mock trial program called Modern Brain. And so if you thought their styles were similar, that's probably why. Great job, ladies. I'm going to ask our judges to share their favorite part of trial from each of the advocates. We'll go clockwise around my screen. Asa?
Hey, okay. Sorry. Hold on, I just got a call. Okay, Anya, I thought that one thing that you did really, really well was the beginning of your cross. I noticed when the defendant was testifying, I saw you like pull out your legal pad and write something down, and I was really excited for you to like flip whatever it was that you wrote down, and then right off the bat you flipped it, and I thought that was great. And then I really liked how you flipped the demo as well. That was definitely a highlight. And then Dana, I really liked the end of your direct. I thought that the way that you just went like bam, 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 and gave us your entire theory. And like the last 5 questions of your direct was like master class. I was like, okay, that is your closing argument right there. So great job on both of those exams. I thought that was fantastic from both of you.
Thank you. Ria?
Yeah, Isa stole some good ones, so I'll think of some new ones on the spot. But for Anya, I have to say I really enjoyed your demo flip during cross. I thought it was really good to get your narrative both back on the record, but also just visually in front of the story. So I thought that was good thinking on your feet. And Dana, I really liked there were some parts of your opening and closing that were particularly just like natural and sounded like you were kind of just being yourself and explaining things to the jury in a very conversational tone. And I thought that was some of the strongest I've seen from you tonally during this trial. Both of you were really, really excellent. Good job.
Thank you. Ken?
So for the prosecution, when you first used PowerPoint in your opening to establish the elements, what was going to be the roadmap for the case. I think show and tell is expected by jurors these days, and the more of it you can do, the better, but it's got to be done effectively. And then for close on defense, you actually argued the charge. Your opponent did not. That's a big problem for me. It all comes down to the charge. And what I typically like to see is you pick up on your opening, but you shoehorn the evidence into the elements where the jury's going to answer the charge. And so the fact that you argued it was good, but the fact that you gave all the evidence before you got to the charge, you lost me there a little bit.
Simone?
I was particularly impressed by both of your ability to weave in each other's themes throughout the entire trial. It was quite masterful. Usually, I see attorneys kind of reserve a theme flip for their closing and they kind of leave it towards the end or even in rebuttal on prosecution or plaintiff. But I thought the way that both of you weave that throughout your directs, your crosses, even in your opening, and then again in your closing was exceptionally well done. And I'll just add just another for the prosecution attorney, Anya. I thought your rebuttal was quite excellent. And is it Dana on defense?
It's Dana, but I
Dana.
go by anything.
Anna, I thought your opening style was incredibly effective. It kind of had me on the edge of my seat, and I could tell you just have a really strong storytelling style and delivery, which is what you should have in opening, but is very difficult to master. So I thought you both did an excellent job.
Thank you. Emberlyn?
Both of you were amazing. So for Anya, my favorite part was definitely your close. I thought you were so responsive throughout, and it was just really like easy to follow. And I thought it was just great. Um, for Dana, I thought you made a lot of common sense points, which is like my favorite thing when attorneys do to make points that make sense. For example, at the end of your like cross, you made the point of why would a doctor for this amount of money do something like this? And I thought that was a great point.
Professor Lester?
I thought you both did really good, really well done. I liked how there were so many D words with decision and doubt and deal, and it's just both themes were a lot of D's. What I liked most about the prosecution case, though, and it's already been said, is the flip and use of the demonstrative and the timeline where you added extra things to the timeline. I thought that was really well done. And for the defense, I really liked how you flipped the D word of disguise and used that and sort of put that back into the prosecution's face. So very well done. This is very difficult to judge because you're just judging one or the other, and it's all or nothing in a category. But the categories are not all or nothing; they are very, very close, and so this is very hard to do. But well done, and thank you for letting me watch.
And fittingly for our international competition, we'll end with our international champion, Rory from Toronto.
Guys, you were both amazing, and I mean, so many of the things I wanted to say already were covered. But Anya, like Isa said, your cross started off with such a bang. You were so responsive, both with what you'd written down, but also just you had these moments that just made me chuckle because this is my favorite type of cross style where you were like, oh, and you bribed them, right? And of course the witness isn't going to agree with you. So you were like, right. No, you just sent them a ton of money. I love that. And it made me chuckle when I was watching. So I really liked that part of your cross. And then Dana, I really loved, and a couple people have already said this, your conversational and storytelling style in your open, especially, I thought it came through really strong. And you had this moment that was just so good where when you were telling the story of how the prosecution was changing everything to be so nefarious when it wasn't, and you went, so then the phone call becomes a threat and the bonus becomes a bribe. And I thought just the way you delivered it was so good. And like Simone said, like kind of edge of the seat storytelling ability. And for your age, it's amazing. So congrats to both of you guys.
This was a wonderful final round. It was a ton of fun to judge. Uh, I think some people probably were bummed when they found out it was two students from the same program. I'm a little biased, but I kind of love same program final rounds. Uh, what I love about them, Professor Lester's giving me a look. What I love about them, apart from the obvious, is that it lets students face a new challenge. How do you deal with an opponent that you know really well and who knows you really well? And I love that you didn't hold back. You went after each other with objections. You went after each other with responsiveness. My favorite part of trial for Anya was, as Ria said, the way you responded to that demonstrative aid by sort of making it yours. And Dana, you're just so easy to listen to, especially in opening. You just have a natural presence. This is a great round. I'm glad I didn't have a ballot. That would have been hard. Fortunately, we had seven outstanding qualified credential judges who did have ballots. And so I'm thrilled to announce that our national champion, our international champion, our 12th Gladiator champion is Anya Luo. Congratulations, our newest Gladiator champion. Give her a round of applause. Uh, and a round of applause to our runner-up, Dana. You were amazing. Dana, excuse me. You were awesome. Nicely done. And you see their spectator Ian, proud coach of both, popped on screen. Very nicely done, ladies. Congratulations, and we'll make sure you get the video and your hardware in the mail. Thank you again to our judges for volunteering your time. I appreciate it. I'll see you all soon.